As the title suggests, over the next hour or so, we'll be tapping into our years of experience in this important area to provide you with information, not just about what we think you need to know, but also what we consider is important to share with you. We share common objectives to protect learners and young people and give confidence to the public, parents, guardians in the work we do. We hope this session will provide some really useful information and insight to help you to do that and further strengthen our professional relationship. So just to introduce those of us here today, I'm David Brown, Director of Regulation. I've been in post since September 2023. Prior to that, I was the head of fitness to practice for nearly 3 years. And before joining the EWC, I was a senior official with a teaching union for 13 years. And in total, I've worked in education for more than 30 years. I'll quickly hand you over to my colleagues to introduce themselves.
Good morning, I'm Susan Street. I joined the General Teaching Council for Wales, or the GTCW, in September 2002 as Professional Standards Officer and became the manager in 2012, and then Head of Fitness to Practice in September 2023. So I have over 22 years experience of the GTCW and the EWC. I'm also a qualified teacher and I previously worked in law enforcement at Heathrow.
Good morning, I'm Rachel Rees. So I joined the GTCW back in February 2007 as an executive officer in the professional standards team. I then moved across between 2018 and 2023 into other teams within the council to gain some further experience, and then returned as fitness to practice manager back in October 2023. So I've been with the EWC or GTCW for 18 years, and prior to joining the GTCW, I worked for the Crown Prosecution Service.
So we've changed a lot as a regulator since 2000, where only school teachers were registered. Today, we regulate 13 different categories of education practitioners in Wales, meaning over 91,000 individuals are registered. Our register is the biggest public register of any profession in Wales and the most wide-ranging register of education professionals in the world. A final reminder before we start, whilst we work through the presentation, we'd ask you to carefully consider any questions that you may want to ask, and you're welcome to put those forward in the chat for discussion later. So on to the agenda for today. We'll be talking to you about a number of different elements of professional regulation in Wales, borne out by years of experience and exposure to casework, legal advice, reoccurring evidential issues, and legal challenges, all of which have left us in a position of knowing what can support and help us both. Our main presentation will be about 45 minutes, and we will finish with a Q&A session. So we spoke in our introduction about our common objectives. Employers and EWC are different in terms of remit, jurisdiction and function, but we do have some shared objectives. Essentially, to protect learners, protect the public, parents and guardians, ensure only those suitable are employed and registered, and where they may not be, take action if necessary, and to uphold the reputation of the education professions in Wales. Our view is that the public, parents and guardians gain reassurance when they can see our organisations working together to achieve these objectives. Mentioned in our introduction about our vast experience in terms of casework. So since the inception of the GTCW in October 2000, more than 1,500 discipline cases. And since we've received the power to regulate in 2001, we've also, since 2006, had to have a process for determining suitability. And since 2006, we've considered more than 3,500 declarations. And in terms of interim suspension orders, we've had that power since 2021. We've considered more than 30 cases in terms of whether or not we should be imposing an interim suspension order. So if you take that lot together, that's over 5,000 cases. Each one is different, each one with their own unique circumstances, facts and challenges. So our unique insights are therefore based on real cases spanning 25 years of professional regulation. Fitness to practice covers not just cases involving those practitioners currently EWC registered, but also those applying to register and those EWC registered who fall under our interim suspension order consideration criteria. For information, we're also the appeals body for those school teachers who fail their statutory induction and wish to appeal against the decision.
Thanks, David. So we first wanted to talk to you about the entry point for education practitioners to work in Wales and the requirement to apply for registration with us and to be admitted to the register. And this isn't an automatic right. We are the gatekeeper of the register. It's set out in the Education Wales Act 2014 that we have to decide whether or not an applicant is suitable to be registered. And we have a responsibility to ensure that only those suitable and qualified with a requirement for qualifications are admitted to the register. So our process is robust, but in common with other regulators, it does rely on the honesty and integrity of a practitioner to tell us about any past or current criminal, employment, or regulatory issues that we need to be aware of. And this is where the declaration side of the application form comes in. So before I go into that in more detail, we just wanted to talk about the importance of pre-employment checks. And it's essential for you as employers to be carrying out those checks before employing someone in a position where EWC registration is required. And the potential consequences and risks of not doing that can be significant. So one of our key messages here is not to assume that someone is registered because they've told you that they've applied or say that they're registered. It's really important that you carry out your own independent check using the employer access. You also need to know that if an individual has applied for registration but made a declaration, that the process may not be quick, as the onus is on the applicant to persuade us that they're suitable. So the time frame around that is usually driven by how and when they respond to our inquiries. And we frequently come across applicants who've not been honest about being registered or not made a declaration when required. And as you'd be aware, the public would expect the employer and regulator to deal with this and take action where necessary. So what are the potential consequences and risks of not carrying out pre-employment checks? First and foremost, employers will be in breach of the Welsh Government regulations, so effectively breaking the law. So during 2024-2025, we found from comparing the register against employment records that actually over 1,000 practitioners in Wales weren't registered, but were already working in positions where EWC registration was a legal requirement. So as you can see, this is a serious instance of wide-scale non-compliance, and employers are at risk in these circumstances of being issued with a Welsh Government directive. So it's not only the responsibility of the practitioner to be registered before working, but also significantly the employer. Second, without those necessary checks and registration, you could unknowingly be employing someone with a criminal record, a live interim suspension order, a refusal from registration from another regulator, or even a DBS bar. So in fact, those people wouldn't be suitable or qualified to practice. And that in turn could mean that you're putting those learners' well-being and education at risk. Third, without the necessary checks on registration, any unknown conduct issue may be repeated. So this could lead to your reputation as an employer and the reputation of the profession as a whole being harmed. Fourth, public confidence in the education professions, employers and regulation could be damaged. Fifth, could be damaged. So in summary, our combined role is to ensure that those unsuitable to practice are not employed and not registered. So how do we decide who is suitable when a declaration is made? And how do we make sure we're following what the Act requires? So now that you've got that fuller picture about the suitability assessments, I'll just explain a bit about how we as officers or independent committees make decisions to refuse or grant registration. And we both have a role to play depending on the type of declaration that's made. So where a decision to grant can't be made by officers under stage 1, which is solely conviction or caution information, or stage 2 of our process, which is more serious conviction information, or that sort of employer or other regulatory information, we will refer the assessment to a suitability committee to decide. And the key question that we're always asking ourselves is the applicant suitable for registration? Do they meet the standards expected of a registered person? And to answer this question, either us as officers or the suitability committee require a number of things. They have to have sufficient evidence, so that could be evidence submitted by the applicant or evidence that we've gathered by the council, so for those convictions or police information. We also have independent legal advice. So we instruct an independent law firm. They don't represent the EWC and they don't represent the applicant. They're there to provide independent advice to committees to ensure that the process is fair, to advise on current case law and ensure it's applied correctly, and to deal with any legal issues arising. We have to apply the appropriate legal test for suitability assessments. So that's the balance of probabilities. Is it more likely than not that the applicant is suitable for registration based on all of the available evidence? And that decision comes from experience and professional judgment, but the burden is on the applicant to prove that they're suitable. And finally, we follow our procedures set out in our rules, our registration rules. It's derived from the legislation. So under this process, we're constantly assessing whether or not there's an ongoing risk that the conduct declared could be repeated if that applicant were to be admitted to the register and begin practicing in Wales. And if so, what level of risk do they pose? Is this an acceptable or tolerable level that will protect learners, young people and the public? So again, finally on this section, I just want to emphasise the combined roles between employers and the EWC as the regulator to ensure that those unsuitable to practice are not employed and are not registered to work in Wales. Thanks, David.
And moving away now from those applying for registration, we want to talk to you next about casework involving those registered with the EWC. You'll know that once registered, all practitioners are bound by the Code of Professional Conduct and Practice, so they should know the standards expected of them. One of our main functions is to investigate and hear cases received. It's set out in the Education Wales Act 2014 that we have to do this where allegations relate to misconduct, professional incompetence, and relevant criminal offences. We have a responsibility to ensure only those suitable remain on the register. Our processes under discipline are driven by legislation. Legislation also sets out your legal duty to refer to us cases where you dismiss a registrant or a registrant resigns while subject to a disciplinary investigation, and you might have dismissed them had they remained in employment. Might have means any possibility. We want to talk more about your legal duty to refer in more detail. It's important that you as employers are referring all cases which fall under the criteria of dismissed or might have dismissed had they not resigned. These are circumstances under which employers must act. The potential consequences and risks of not doing so could be significant. For example, first and foremost, employers will be in breach of Welsh Government regulations, so effectively breaking the law. Second, if no referral is made in the relevant circumstances, employers will be allowing the conduct or competency issues at large to persist unchecked. Perhaps the practitioner will go on to practice in another education setting and repeat the same behaviours which caused enough concern to dismiss previously. Third, if no referral is made in the relevant circumstances, employers will knowingly be putting learners' well-being and education at risk. So if no referral is made in the relevant circumstances and the known conduct issue is repeated, your reputation as the former employer and the reputation of the education professions as a whole could be harmed. As with our coverage of pre-employment checks, public confidence in the education professions, employers and independent regulation could be damaged if referrals are not made in line with legislation. If you have any doubt that a referral should be made, please contact us. There may be circumstances where you think the wrong decision was made. Perhaps a finding of gross misconduct led to a decision falling short of dismissal, or a dismissal was later substituted with a final written warning following an offer of resignation. Or perhaps a settlement agreement was reached, which would otherwise have resulted in dismissal. Our message is that we still want to know. We can still investigate. The legal duty to refer relates to circumstances where the employer must refer. It doesn't mean no other case can or should be referred. You also need to know that if we become aware of allegations about which we as a regulator have concerns, we may contact you for that referral so we can decide whether or not to investigate. In summary, again, our combined role is to ensure those unsuitable to practice are not employed and are not registered. Finally, on this point, just a bit about the code. It's important to note that employers are not in a position to decide if an employee has breached the EWC code, only their own staff code of conduct. We mention this because a lot of referrals include an allegation that the EWC code is breached at the point of referral, but only a fitness to practice committee at a hearing can decide if there has been a breach. So our remits are defined and separate in this respect. We can illustrate these issues further about non-referral by giving you some examples of cases which were eventually referred to us, but were not at the point where the requirement to refer was first met. As employers, please consider the issues which arise here. So before we move into the next part of our presentation, and because we will be talking to you mainly about disciplinary casework, we wanted to show you a summary of what the disciplinary process looks like and what decisions can be made. We won't focus on how decisions are made at this point. We will come to that later, but we will mention the disciplinary orders available to a fitness to practice committee at a hearing. This means allegations have been referred by an investigating committee, and a fitness to practice committee now has to make a number of decisions which might result in a disciplinary order. So I'm just referring to the boxes at the bottom of this slide here. So first, a reprimand. This is the lowest sanction. If imposed, it's recorded in the register for 2 years. This won't prevent a registrant from continuing to practice. Conditional registration order. This includes conditions which must be met in order to remain registered, either within a specified time frame or without a limit of time. Suspension order. This suspends a practitioner from the register for a time period of up to 2 years. The duration is decided by the committee, depending on its findings. Conditions can be applied to this order to be met within the time frame of the order. And a prohibition order. This is the most serious sanction. It removes the practitioner from the register indefinitely, making them ineligible to practice. A committee imposing this order must specify a time period after which the practitioner can apply to have their eligibility to register restored. This means another committee in another hearing will decide if the practitioner can show they are suitable to return to the register. We hope this summary will help set the background of the main part of the presentation, which now follows. So now we come on to the focus of our presentation and information we ask you to take particular note of. We think this is highly relevant to strengthening our professional links and aligning our common objectives. The common objectives you see here are as a result of years of exposure to casework and its challenges we spoke of earlier. This list summarizes the way we conclude that case prospects are strengthened and hindered in almost equal measure. We can explain how case prospects can be strengthened as soon as an allegation is reported locally. In sharing these professional insights, our objective is to enable us both working together to achieve proportionate decisions which protect learners and young people and reassure the public that we are acting within our defined remits where necessary. So we'll go through each of these points in turn. Firstly, key witnesses. We want to explain what we mean by key witnesses, and they are those witnesses who saw or heard events firsthand. Key witnesses play a crucial role in helping a fitness to practice committee establish the facts. In case law, committees cannot rely or know about employer findings, so ideally need to be able to scrutinise witness evidence. Key witnesses who appear in person to give evidence can be questioned and cross-examined, hold greater weight evidentially than any evidence on paper. By evidential weight, we mean evidence which is closest to the event, so the believability or persuasiveness of it. For example, a witness who saw and heard an event, recorded it soon after, gives evidence in person and is cross-examined, will hold the greatest evidential weight in these proceedings. So to enable attendance of those key witnesses and to strengthen case prospects, we offer these pointers. You should warn key witnesses that their part in the investigation may not end once your disciplinary decision is made. Highly likely, we will want to at least speak to them if your referrals end up in a fitness to practice committee hearing. We have had cases where key witnesses have refused to take part again, as they were told their involvement would end with the employer process, meaning the registrant has been sanctioned with more leniency, perhaps, by the EWC. Engagement. Where key witnesses do not engage with us, it means there is a real risk that facts will not be proved. So please share up-to-date contact details at an early stage and flag any contact problems or reticence to being involved. We have had, excuse me, we have had many cases where key witnesses have refused to take part again, become hostile, or we cannot locate them. The latter is particularly relevant to learners. We ask you to fully engage with our attempt to contact witnesses who may not want to be contacted again or can't be traced, as this can seriously affect a case's prospects. We have powers to summons witnesses, but aim to avoid using those powers. Credibility. Some key witnesses will make better impression than others, and therefore their evidence may be preferred. That's a fact. We've had many cases where key witnesses have backed down from their original evidence, changed their evidence, or made it known they have issues being questioned or appearing at all. This will affect a case's prospects, as a committee may find their evidence unreliable. Vulnerable witnesses and anonymisation. Key witnesses who are vulnerable can be afforded special measures to assist them in giving their best evidence. We have managed to engage many vulnerable witnesses with offers of support to enable them to give evidence, particularly when they are key to a case. But some have refused, affecting a case's prospects. We ask you to flag at an early stage if you're aware a key witness has any vulnerability which might affect their ability or willingness to give evidence in public proceedings. Moving on to anonymisation, it's important that you know that this is a high bar in legal regulatory proceedings. So unless, for exceptional reasons, for example, children, highly vulnerable witnesses, those at risk of jigsaw identification or other specific protection issues, witnesses will be named. So it's important that you and they know this. We can illustrate this further with a real case example. The key witness in a case, colleague A, had been a key witness in the employer process and employment tribunal and was told their involvement would end there. Despite repeated attempts to re-engage them, they would not attend and provide witness evidence again due to their experience. We believe the registrant would have received a higher disciplinary order had this key witness, the victim of the conduct, attended. Excuse me. 2, learner evidence. First, we want to explain that by learner evidence, we mean generally children, young people, those aged under 18, and those witnesses on the receiving end of specific conduct. It's important to note we aim to avoid calling any child as a witness due to their obvious vulnerability. So the written evidence provided by learners and young people, as obtained by the employer, plays a crucial role in particular proving any form of safeguarding allegation. This kind of evidence is likely to be heavily relied on in the absence of the child, young person, or young adult. However, written evidence may cause evidential problems and can be challenged as unreliable or deemed hearsay, which carries a lower evidential weight in regulatory proceedings. By hearsay evidence, we mean second or third-hand witness evidence in any form, not first. To ensure this evidence is accepted and given weight by the committee, accept that the employer's approach to gathering this evidence is likely to be scrutinised by a fitness to practice committee. For example, whether or not contemporaneous witness statements were taken, that is, recorded at the time the events took place. And if they weren't, why were they not? Whether learners had an opportunity to discuss what they heard or saw with others before being interviewed. Whether learners were interviewed in groups or on their own. How learner statements were recorded. Provenance, so dates, signatures, names. By provenance, we mean ensuring the origin, excuse me, authenticity and reliability of documentary evidence gathered in a case. If there have been similarities in versions of events, has there been any collusion? Whether or not policies were followed. If not, this may suggest unfairness or a tainted investigation. and whether key evidence is captured in documentary form. For example, where social media has been used by the registrant to contact learners, are there screenshots taken of the messages? So where the committee has concerns, the evidence may be deemed unreliable, unsafe, or inadmissible. Challenges to hearsay evidence are increasingly common. We have seen many cases in the past few years where the evidence of learners has been deemed inadmissible by a committee, meaning the case referred has failed, all or in part. This has been in many cases down to the manner in which learner evidence was recorded or policies were not followed in the way it was gathered. As employers, you need to ensure you are following policies, showing independence in gathering evidence, and taking great care that evidence is recorded fully, challenging inconsistencies or similarities so committees do not question evidence admissibility. We can illustrate this further with a real case example. A registrant was accused of throwing an object at a learner during teaching time, causing injury. The learner could not be located, so could not be called to give evidence. Their written evidence, which lacked detail, was therefore treated with caution by the committee and as hearsay, as it could not be tested by cross-examination. There were no other witnesses. The employer's investigation was also found to be deficient, as not all relevant factors were taken into account. The committee found there was insufficient evidence to show the conduct was deliberate and targeted at the learner. The facts were proved, but not deemed unacceptable professional conduct. Number 3, evidence provenance. By provenance, we mean ensuring the origin, authenticity, and reliability of documentary evidence gathered in a case. The provenance of documentary evidence plays an important role in helping a fitness to practice committee establish the chronology of events once an allegation is made, what processes were followed, what was corroborated, and the facts in the absence of witnesses. Evidence lacking corroboration or missing documentation will put a committee in a difficult position of not being able to establish certain facts. We have seen entire cases thrown out or fail as a result of hearsay evidence, which was relied on as key evidence being deemed unreliable. To ensure documentary evidence assists the committee, ensure evidence provenance is at the forefront of your approach to any investigation and disciplinary process once an allegation is made. With documents as a minimum, these should allow a committee to establish what, who, and when. They should also include an endorsement of signature and letterhead where possible and relevant. This applies to formal statements, informal notes, interview notes, minutes, memos, and letters. Hearsay. Without provenance, specific documents are likely to cause evidential problems and potentially be challenged as unreliable and inadmissible under the banner of hearsay evidence, depending on the significance of that evidence. Any evidence deemed hearsay will be given lesser weight by a committee, or a committee may decide the evidence should be disregarded altogether if it decides it's unfair to proceed with it. And policies. Employers should also ensure all relevant policies in force at the time of an allegation are provided with the referral. Those which apply during the investigation or disciplinary process should be clearly dated and signed off. 4. Interrogation of evidence. First, we want to explain that by interrogation of evidence, we mean fully testing the validity of evidence through various means. The Fitness to Practice Committee's first role is to establish the facts of a case in an investigative and fair manner. It cannot simply adopt the employer's findings or decision. In fact, it's prevented from knowing what those outcomes are in case law. The committee's jurisdiction is also different. Not whether or not a practitioner is suitable to remain in employment, but whether or not a registrant is suitable to remain registered. As such, how the employer has investigated an allegation will be looked at. The committee has to be in a position to establish its own understanding of the facts and decide what is proven and what is not. A committee's conclusions may therefore differ from the employer's findings. That said, the committee's role is not to undermine the employer or to undermine how it acted. The committee simply has no jurisdiction to do so. So to ensure a committee considers the way an employer investigated an allegation was fair and thorough, and therefore assists it in establishing the facts, ensure disciplinary policies and procedures are followed and referenced, and legal advice is taken if necessary. Ensure there is full independence in any investigation carried out without bias or prejudice. Committees occasionally find this has not been the case and therefore cannot fully rely on the employer's evidence. Ensure the allegations and evidence available and relevant witnesses are fully tested. Ensure the correct witnesses are interviewed. Where relevant witnesses cannot be interviewed, document why. Show that similarities in evidence or possible collusion are tested further. Be aware of possible issues which give rise to the allegation in the first place. For example, perhaps there's been a clash of personalities or there are relationship histories. Ensure there is evidence of the registrant being provided with a full opportunity to engage, respond, participate, and of their evidence being taken into account. And ensure every part of the investigation and all evidence is fully documented. In particular, witness evidence recorded at the time of the event, interviews, meetings, and outcomes. Remember provenance in all that is recorded. So we can illustrate this further with a real case example. This case included video evidence, but concerns were raised by the committee after it questioned the investigating officer. It transpired this officer had not been thorough in their approach to selecting and interviewing first-hand learner witnesses, of which there were many. As a result, very little contemporaneous witness evidence existed, and very few questions were asked to those witnesses, leading to concerns about reliability. Facts not proved. 5. Previous concerns and warnings. Previous conduct can have a significant impact on a fitness to practice committee's professional judgments relating to unacceptable professional conduct, serious professional incompetence, and the relevant offence. These are the definitions and legislation of the possible conduct fitness to practice committees are tasked with establishing, given any facts found proven in a case. Previous conduct can then go on to impact a committee's decision about a disciplinary order considered appropriate, proportionate, and necessary. A bit like sentencing in a criminal court where a previous record is not disclosed until after the facts are decided. So if a committee is made aware in evidence of a registrant not responding to previous warnings for similar conduct, it's likely to form a different view of what is necessary and proportionate, leading to a more serious outcome. So a full picture is therefore highly relevant. To ensure a committee is fully informed of historical warnings which should have mitigated future repeat conduct, ensure all evidence of any previous concerns, investigations, or warnings, informal and formal, for related conduct is provided when the referral is made. This includes anything pending at the time of referral. Particularly relevant is evidence of repeated conduct where warnings were still live. If you're in any doubt, please contact us. It is routine that we will contact you to query it in any event. And employers will not be in breach of their legal duty to refer by providing this information. As already covered, regulations refer only to when employers legally must refer. It does not prevent other evidence or outcomes being provided. And 6, thresholds. Employer, dismissal, and the EWC, unacceptable professional conduct, serious professional incompetence, and a relevant offence. This is about our responsibility to make different decisions in our respective remits. You need to be aware that fitness to practice committee findings may not align with employer findings. This is because both operate under different jurisdictions and perform different functions. Fitness to practice committees identify and address failings in practice impacted by conduct or competence issues raised by the employer. And those committees go on to decide if a registrant's eligibility to practice in Wales, meaning eligibility to be employed in their specific area of practice, should continue. In summary, Employers decide whether an allegation means an employee should be warned or removed from employment altogether for a breach of terms and conditions of employment or a staff code. This involves one employer. Dismissal from employment is the legal trigger for referral of a registrant to the EWC. The EWC decides whether allegations referred to it mean an EWC registrant should have their registration affected in some way or removed from the register altogether. This could remove their eligibility to practice in any education sector in Wales. It may also affect the future practice in England, Scotland, Northern Ireland, and the Republic of Ireland. Due to these different functions and case law, investigating committees and fitness to practice committees cannot simply agree or align with the findings and decisions the employer made. Committee decisions are independently made based on the evidence it receives and hears, and relate to future registration, not future employment. So gross misconduct does not have the same meaning as unacceptable professional conduct, for example. Different tests apply. Consequently, our message is simply that committee findings may not align with employer findings in this respect. So now we've highlighted these issues with you. Here's our summary of what we, in our experience, we think makes a good referral. That is one that is ready for investigation and is likely to have limited evidential problems. Do you understand and make reference to the EWC Main Functions Regulations 2015 Schedule 5 Part 1 before referring? This sets out the information and evidence which should be provided in a referral by an employer if available. And, excuse me, in accordance with those regulations, refer in the correct circumstances where there is a dismissal or might have scenario. But as previously mentioned, we also invite conversations where those thresholds are not necessarily met. So referring at the right time, that is the end of the appeal period. In other words, when all procedures are concluded, including any final appeal against a decision to dismiss. It's also important to flag that we don't need early notifications or to be told about the suspension of an employee, or be informed, by example, by an agency that has stopped offering work to a registrant or their work is on hold. Also, Part 5 outcomes are not referrals, despite what the police or the local authority designated officer, the LADO, might say. If there is a substantiated outcome, the employer or agency should go on to fully investigate the allegations in line with their own disciplinary procedures and then refer to the EWC in the usual circumstances. We would expect an employer to still go on to conclude an investigation, arrive at an outcome, even where the registrant has left employment, as we cannot carry out investigations for employers. This is all, of course, unless there's an interim suspension order implication, and we'll talk a bit about that shortly. These scenarios otherwise suggest the internal processes are not concluded. But moving back to the summary, details and issues. So you provide a cover letter clearly stating reasons for referral, the name of practitioner, the employer, the allegations, the outcome. This helps us quickly establish the facts of the referral, which we thereafter keep as a reference point for the case. You flag specific issues at the outset, for example, the ill health of the employee registrant at the time of the investigation decision, the vulnerabilities of the registrant and or witnesses, and any issues which affected the investigation. This gives us important information about how to manage the case to investigation and potentially hearing. And you provide a list of key witnesses and contact information. This helps significantly if a case is referred by an investigating committee for hearing. Chronology. You provide a chronology of events to accompany the evidence and put evidence in a chronological order or by process. This helps us understand the evidence and how it developed during the course of the internal investigation. Evidence. Provide all evidence which led to the final decision being made. We find we often don't have everything that was available. You provide written witness evidence where possible, signed and dated. This is the best form of documentary evidence for a first-hand witness, save for hearing from them in person. You provide documents that are signed, dated and letterheaded, so the origin of them is clear and validated. and you provide policies in force at the time the allegation arose. We have heard many cases where the committee has been faced with an outdated policy which is not relevant to the case, causing allegations to weaken or fail. Previous warnings. You make clear at the outset there have been previous warnings for similar conduct and provide all evidence relating to those previous warnings. We routinely ask and often find we don't have all the evidence that is available in this respect. And redactions. You carry out redactions you deem necessary. However, those redactions will still need to allow a committee to make a decision it is being asked to make. For example, where pupil names are redacted in evidence, we will still need to know the names of those pupils in the form of an ID key, which would be helpful. When we say good referral, we also mean that from the time the allegation is made to the point of referral to us, the learning points we have shared with you today are adopted. And all referrals should be made via our website. We hope you found this useful information. So moving away from that focus, and we talked earlier about suitability for registration decisions and how they're made. So now we have taken you through some important fitness to practice casework issues. How are these decisions made and how do we make sure we do as the Act requires? Again, we as officers and independent committees both make decisions depending on the kind of case received. And as with suitability assessments, every decision needs evidence, independent legal advice, a legal test, and a procedure. So in the early stages of a referral, the key question for officers is this: are the allegations referred capable of amounting to an allegation of unacceptable professional conduct, serious professional incompetence, and/or a relevant offence? If so, the case will be referred to an investigating committee. If we as officers consider a case is not capable of amounting to an allegation based on our previous experience and knowledge of casework, the seriousness of the allegation, and with reference to the public interest, we can decide to take no further action. An example of this kind of allegation might be a caution for theft, shoplifting, which we know from years of investigating committee decisions will not be referred to a fitness to practice committee for hearing if an isolated offence. The question the investigating committee is required to answer is this: is there a case for the registrant to answer? The legal test for investigating committees is the real prospect test. So is there a genuine rather than a remote or fanciful possibility of the facts being found proved and unacceptable professional conduct, serious professional incompetence, and/or a relevant offence being established before a fitness to practice committee? An investigating committee cannot resolve conflicts in evidence or establish facts in making its decision. So under this process, the investigating committee is deciding whether or not the case should be referred to a fitness to practice committee for hearing. So moving on to fitness to practice committees at hearings, our final coverage of decisions made. This is a more complex process, but committees always follow the same four-stage decision process. You may want to draw comparisons with how disciplinary decisions are made in your settings as we work through this. So what are the four stages? Stage 1, are the alleged facts proven? The alleged facts are those set out in the notice of proceedings, which we copy to you as employers. This is a balance of probabilities question based on all information available in writing and evidence provided by live witnesses. The burden on proving these facts is on the presenting officer, not on the registrant. In order to decide, a committee might need to resolve conflicts in the evidence. So, for example, decide which evidence is preferred, and this could be down to witness credibility or who is believed, and assess weight of evidence, so decide which evidence is closest to the event and therefore credible. Stage 2. If the alleged facts are proven, any or all, do they amount to unacceptable professional conduct, serious professional incompetence, and/or a relevant offence, whichever is alleged? This is a professional judgment for the committee, and the definitions of unacceptable professional conduct, serious professional incompetence, and a relevant offence are set out in legislation. Stage 3. If unacceptable professional conduct, serious professional incompetence, and a relevant offence is established, any or a combination of any, what mitigation is there? This can be evidence of previous history, good character, good professional conduct, or the registrant might explain to a committee that at the time of the conduct found proven, they were suffering from some form of ill health or personal circumstance which impacted their behaviour. This is all relevant to any order a committee might decide is necessary and proportionate to impose or not to impose an order at all on an exceptional basis. Added to this, the presenting officer must also inform a committee of any previous history they are aware of on our behalf, so it's fully aware of all previous history relevant to its final decision at stage 4. This might include a live disciplinary order imposed by the EWC or another regulator, or an interim suspension order. And stage 4. Finally, what disciplinary order, if any, should be imposed to protect learners and the public? The indicative sanctions guidance is the focal point for the committee at this final stage. This guidance sets out what order might be appropriate given the facts found proven, and what the registrant has said in reply, if anything. For example, if they have admitted the conduct and shown insight, it will make a difference to what the committee decides. The indicative sanctions guidance is a guide only. It is not a checklist of criteria which, when met, means a specific order will be made. This again is a professional judgment for the committee. Any order imposed must be necessary, proportionate and fair, and must adequately protect the public, learners and young people. And how do we protect the public, learners and young people once an order is made? In a number of ways. The committee must announce this final decision in public, regardless of whether there has been any part of it held in private. Where any disclosure of the details of a case could be detrimental to a group or individual protected by privacy, the decision announced may be very high level. For example, facts were proven and an order was imposed. What can't be protected is the name of the registrant involved, or the public, learners and young people cannot be protected by the decision. Also, a summary of the case and the order will appear on our website for 6 months, so anyone can see this summary. The order will also appear on our website until it expires, so anyone can see the online disciplinary order list. And the order will appear on the public register until it expires, so anyone can search the public register. We also inform our equivalent bodies in England, Scotland, Northern Ireland, and the Republic of Ireland where the order affects a school teacher. This is because no other equivalent body registers any other category at the moment, but orders made in Wales apply across the United Kingdom. So we want to emphasise there is a public element to this process and the outcome. You'll know there is a presumption that hearings are held in public. We have a duty as a regulator to be transparent, so anyone can observe a hearing, including the press, provided there is no element of privacy involved. Press frequently attend and report on the evidence they hear, and we have no control over the content of the press reports.
Thanks, Sue. So just bringing this part of the presentation to a close, we just wanted to talk to you briefly about interim suspension orders or ISOs. So ISOs are commonplace amongst other regulators in healthcare particularly. And after much lobbying by senior officers at the EWC, we finally received powers from the Welsh Government in April 2021 in relation to ISOs. And these powers mean we can remove practitioners from the register as an emergency measure quickly where the most serious safeguarding allegations are made. And this is what the public would expect we're here for. But what we didn't expect was the number of those we have imposed since that date. So as you can see from the slides, we've imposed 28 interim suspension orders since 2021. We thought we'd probably have 2 or 3 a year, but as you can see from the data, we've received far more than anticipated. So the maximum duration an ISO can be imposed for is 18 months, and every ISO must be reviewed during that period to ensure any changes in circumstances that led to the ISO being imposed are considered. Obviously, an ISO is a punitive measure, so each one is carefully monitored to ensure they remain necessary and proportionate. Most matters are disclosed to us by the police, as we're told about arrests involving those registered with us. And when we say arrests, we mean specifically for serious sexual misconduct, causing serious physical, emotional, mental harm, or serious criminal investigations of a safeguarding concern. And just to give you some examples, if we move on to the next slide. So as you can see from these examples, to allow these practitioners to stay on the register while the police are investigating concerns like these would pose far too great a risk to the public, to learners and to young people. And also there would be that issue of public perception. So we must act in these cases, even where these registrants are on remand. The facts don't need to be proved at this stage. This is a risk assessment process. Most of these cases will end up in the press when the practitioners later appear in court, as they are very public matters, and the ISOs will appear on the public register until they're removed or revoked. So as officers, we assess the risk when we receive these disclosures from the police and make a recommendation to a committee to impose an ISO. A committee doesn't have to agree with our recommendation. They make the decision as to whether that ISO should be imposed. You as employers in these kinds of cases, which generally involve bail conditions, which prevent the registrants having contact with people under the age of 18, are also likely to suspend. Again, that's an emergency measure, but one that only affects their current employment. So our role is to look at removing the eligibility to practice anywhere in Wales in that category of registration. So it's just some final points to draw your attention to in relation to ISOs. Generally, we do need a police disclosure to recommend that an ISO is imposed. However, we have found that the police don't always tell us when individuals are arrested for offences such as these. It may depend on what the registrant has told the police their occupation is. So if you do become aware of arrests for any circumstances such as these, please do let us know. We can make contact with the police forces then to get the relevant information that we need from them to take it forward. If an individual is subsequently found not guilty at court, or if the police decide to take no further action, we do still need to assess the ongoing risk to see whether the ISO should continue. So we may be getting in touch with you as employers then for information or evidence relating to any internal investigations that may be ongoing. We will notify the employer when an ISO is imposed, so it's really important that the correct employment information is on the register, and similarly we'll notify you for any ISOs that are revoked. You'll also be able to see when you're doing those pre-employment checks we talked about earlier, whether an individual is subject of an ISO. So again, really important that you are doing those checks before employing anybody. Thanks, David.
So that concludes our presentation for today. So we hope you found the information that we've shared will prove not only useful, but bolster our professional links with each other and also our sort of shared objectives. So we've got a little bit of time just for some questions, although not a lot. But so I've got a question for you, Rachel, if that's okay to start with. And the question's come from Jenny, and it's a question: if registration has been refused, can applicants apply to be registered in another category before 12 months is up?
Yes, so they can't apply for registration in the category that's been refused for 12 months, but they are able to apply in another category. Obviously, they would need to go through the same process, the same sort of level of scrutiny as they did previously. But the legislation, the rules would only apply the refusal to the category they were refused for. So although they can apply, obviously the committee would, or officers would need to consider that information again and see if that was relevant to the new category that they were applying for.
Thanks, Rachel. And then Sue, a question for you from Julian. Do you have any resources available which can be shared with witnesses as part of our investigating, which makes them aware of what could be expected of them should an investigation progress to an EWC hearing?
Thank you. We do have leaflets available, which at the moment relate to an appearance at a fitness to practice committee hearing. I don't know whether that information would be useful to employers to share. We can certainly make that available if that's of interest, but we do have leaflets in place once a case is referred to hearing that we can share and are shared with witnesses, if that helps.
Thanks, Sue. And I'll come back to you with just another question. Sian has asked, is there a template for what a good referral looks like?
Well, in the when you make a referral online, you do need to complete a form which is comprehensive and does cover most points that we've covered here today. So you should find that process is easy to follow once you're asked questions in that way. We may consider expanding that given what we've done today, because it has allowed us to review our process. So we'll look at that again, but you should find that that form online covers all the aspects of a good referral.
Thanks, Sue. Question for you, Rachel, from Emma. What information can be provided by an employer to support an employee who's been referred by the police to the EWC?
Thanks, David. We have actually developed some new guidance recently, or supporting information recently for registrants going through our fitness to practice processes, to provide some signposts into sort of supporting agencies externally that might be able to support. So again, I'm not sure whether that's something we've shared with employers, perhaps something that we can circulate, as well as those leaflets around witness support. But we'd also sort of encourage anyone to get in touch with us as well if anyone does have any concerns, any registrants. The way that we deal particularly with police referrals can vary quite greatly depending on the nature of the caution or conviction or information. So perhaps just getting in touch with us to talk through those processes, we might be able to give some guidance about how we'll be dealing with it, and what the matter sort of might look like. Or similarly, if the employer wants to get in touch with us to discuss that, because particularly with police referrals, they can vary quite greatly. But said, we do have now that supporting information for registrants. As you know, we appreciate it's a really stressful process to go through, regardless, you know, of what's gone on. So anything we can do to support registrants going through those processes, you know, we do where we can.
Thanks, Rachel. And then final question that I have, I'll ask you, Sue, which is from JP. The question was asked in Welsh. You mentioned the code earlier. I think you've had a public consultation. What changes are being made, and when will the new version be issued?
Thank you. Yes, we did have a review earlier on in the year, and the amends were put to public consultation from February to March this year. The current draft is going to committee this week and then on to council, but essentially the main change or the main proposal is to introduce a new principle for leaders and those in management responsibility positions. And we've also made some other minor changes, some reflecting the casework we see frequently. So we're trying to bolster some of those expectations, and some other less significant changes. But once the code is passed through council later on in the year, the new version should be published in September 2025.
Thanks. Thanks, Sue. So essentially then, I think we've answered all the questions that we put in. So thank you very much. So just before we close, there are a number of other resources and services that we offer, and you can get information about those via our websites. Obviously, we provide staff training around fitness to practice matters such as the code, and also training around social media advice and things like that. But as I say, if you look on our website, you can see many of the additional things that we offer. So thank you very much for joining and engaging with us today. If you have anything else that you'd like to discuss, you know, please do get in contact with us. We're more than happy to have conversations with you. Have a good day. Diolch yn fawr i chi gyd.